Everyone, and welcome to today's webinar, Payday Loans, Too Good to Be True. Today we are running this webinar from the Legal Aid New South Wales Central Sydney office as well as the Tamworth Legal Aid office. And so we would like to acknowledge the traditional custodians of the land, the Gadigal people of the Eora Nation and the Kamilaroi people, and pay our respects to elders past and present, and also extend that respect to any Aboriginal and Torres Strait Islander people listening today. My name is Heidi Campbell. And I sometimes work in the civil law team and sometimes in the CLE or community law legal education branch. And today I'm joined by Dana Beglari. Hi, Dana.
Hi, Heidi. Thanks for inviting me to speak today.
Okay, and we're also, as you would have heard, joined by the producer of the webinar, Jessica Sullivan. Jess will be handling the poll questions today and any questions you might have as we go along today.
Thanks, Heidi. So let's start with a poll question to get an idea of how much experience you all have with payday loans. So a poll question is just about to pop up on your screen. So how often do you assist clients who have taken out payday loans? Not often, all the time, sometimes, or never. Just give you a couple of moments to do that one. Okay, great. Okay, so we've got most people clicking sometimes, a couple with all the time, and some not often, but mostly sometimes. So we've got a good audience, guys. All right, back to you, Heidi.
Okay, thanks, Jess. So today, the purpose of the webinar is to help you better understand what payday loans are, the context in which they occur, and the law that regulates payday loans. So the topics that we're going to cover include: what are payday loans? What is responsible lending? What laws apply? Alternatives to payday loans, and where, and most importantly, can I refer my clients for legal advice? We will also discuss the recent changes to the regulation of the financial services industry with the merging of CAO and FOS into AFCA. So the next slide. Basically, Dana, if our audience today had to remember just three things, what would you say they would be?
I think my three main tips to listeners are that there's alternative to payday loans, there's laws in place that can protect our clients, and finally, that it's never too early or too late to get advice. So just to expand a little bit on those, with the alternatives to payday loans, people can get caught easily in a debt spiral, and there are accessible and easy solutions to payday loans. They do exist, and we will talk generally about some of them a little later in the webinar. We'll also talk about the laws that are in place that can help and protect our clients from signing up to payday loans that are unaffordable. And we'll also talk a bit about the remedies that are available for our clients, for example, to reduce the fees and charges that they pay where they've entered into an inappropriate loan. And finally, the third take home is it's never too early or too late to get advice. We'll talk, like you said, about the referral points. A couple of common ones are Legal Aid New South Wales or community legal centres or a financial counsellor. And we'll provide a comprehensive list of legal service providers who can assist towards the end of the webinar. And I note that we'll also include this list in an email that we send out after the webinar.
Okay, wonderful. Thanks, Dana. So let's get down to the nuts and bolts of it. What is a payday loan?
Payday loans are also referred to as small amount credit contracts or quick loans. They're a type of credit that focuses on lending small amounts of money quickly, and specifically a payday loan is a loan up to an amount of $2,000, and it must be repaid within a specific period of time, so 16 days to 1 year. Yeah.
Okay, right. And so how do clients pay it back?
So the most typical way that clients pay back payday loans is via direct debit from their bank account. But I have seen situations as well where people arrange for their employer to make payments directly from their paycheck. Payday loan companies generally focus on providing small amounts of cash to people quickly, like I said before, and they make the process really easy. And the clients that I work with, I find are vulnerable people in disadvantaged circumstances who need small amounts of money fast. And usually they need this money for essential expenses until their next paycheck or until their next amount of money comes in from Centrelink. And many of my clients are often in a position of financial hardship already, and I imagine that a lot of the audience would have had a similar experience with their clients.
Right. So you were saying that these payday loans involve fees. So can you tell us a bit more about the fees?
So the amount of fees and charges that payday loan providers can charge consumers is regulated by the law. Typically, payday loans contain an establishment fee and a monthly fee. And if you fail to make a repayment, you'll also be charged a penalty amount, such as default interest or a late fee. So just to kind of explain a little bit about the establishment fee and the account fee, the account monthly fee, how that might work in practice. If I was to take out a payday loan for $1,000 for a term of 2 months, the establishment fee would be 20% of that amount, so $200. And the monthly fees would be 4%, so $80. So I would end up paying $280 on top of the $1,000 I initially borrowed. And then if I'm unable to make repayments on my $1,000 payday loan, I will usually be charged a default fee until I repay the outstanding amount in full. The maximum that a payday lender can charge is twice, so 200% of the total amount of the loan. And this includes any repayments you made under the contract, plus any default fees. So based on that example, you can see how clients might struggle to pay off the principal amount of the loan as well as these additional fees, and can lead people into a cycle of debt and disadvantage, which places them in further financial hardship. But because of the nature of these loans, there are protections offered under the law to consumers, and I'll discuss these in a little bit more detail further along in the webinar.
Wow, thanks, Dana. You can see how these small loans quickly add up. So what I want to talk to you is about the places where people or our clients are getting these payday loans. So I know now that it's very accessible, and to get a payday loan, it's not just a shop front like the old pawn shops from which clients can access payday loans. They're now accessible from websites, apps, loan ATMs known as ATM kiosks where you can easily withdraw cash. So it appears that payday loans are more accessible than ever. Is that right?
Yeah, I think that's right, particularly with the rise of technology. And as you say, being able to download an app or access a website from your smartphone means it's very easy to access a payday loan or make an application for a payday loan. There's some common companies that the audience might recognise that come up regularly in my work. So Cash Converters, Nimble, Cash for Me, Cash and Go are those loan ATMs that you mentioned before. So those are just a handful of common payday lenders. But there's also, apart from payday lenders, I'll just make a brief comment that there are other debt traps that consumers can fall into with short-term credit providers like Signo and Gold and Silver Finance. There's also pawn shops or consumer leases, and also buy now, pay later products like Afterpay. And there's also, when people are in financial hardship, credit reporting companies like My Budget and Fox Symes that say they can assist a person to repair their credit and help manage their debt, often for a large fee. But today we're only talking about payday loans. And so in the context of payday loans, lenders have responsible lending obligations and are required to comply with the laws that protect consumers. And as I said before, because of the nature of payday loans, there are special obligations that payday lenders must comply with before they grant a loan.
Right, okay. So if you just give us a brief rundown, what are these responsible lending obligations?
So the responsible lending obligations essentially are laws that protect consumers from signing up for unsuitable contracts, and they protect consumers from predatory lenders.
Right, okay, so I guess we're getting to the dry stuff a little bit now. It'd be great if you could actually talk to us about what are the laws that apply to payday loans.
Absolutely. So there's two main pieces of legislation that apply, and the audience, you don't need to remember exactly the details of this. All you need to remember is what the laws mean and the general essence of it, and I think that'll be enough to spot the issues and make an appropriate referral. So the two main pieces of laws that we'd look at with payday loans are the National Consumer Credit Protection Act, I'll just refer to that as the Credit Act, and the Consumer Credit Legislation Amendment Enhancements Act. So I'll just refer to that as the Enhancements Act. And so the Enhancements Act applies only to loans that were entered into after March 2013. I might just note as well that ASIC has a very useful regulatory guideline called Credit Licensing Responsible Lending Conduct that outlines some of the obligations on lenders about lending responsibly. And so I think it's a pretty useful resource. I look at it all the time, and it might be useful for the audience to have a look too. You can find it on ASIC's website. If you just search Regulatory Guide 209, it should pop up. So the two main laws that I mentioned, the Credit Act and the Enhancements Act, they apply to all credit contracts which have been entered into mainly for household and domestic purposes. And before providing credit, the lender must make reasonable inquiries about the person's requirements and objectives, and they must take reasonable steps to verify the consumer's financial situation. Once they have this information, the lender then needs to assess the consumer's capacity to repay the proposed loan without substantial hardship. And based on those inquiries, the lender needs to make a determination about if the credit is unsuitable for the consumer. As part of that process, a common next step for me once I've met a client who has a payday loan is to talk to them about requesting a copy of the assessment that the lender made about whether the credit is not suitable for the client. And you would be able to request this on behalf of your client if you wanted to from the lender, and you could address your correspondence to the complaints contact on the AFCA, the Australian Financial Complaints Authority website.
Okay, wonderful. Thanks, Dana. And why would someone want to request a copy of their assessment?
So you might want to request a copy of the assessment about compliance with the responsible lending conduct to basically assess if the lender has done what they're supposed to do according to the law. And when you have a look at that assessment, you can see how the credit provider has worked out if the loan is in fact suitable for the consumer, and you can see your client's capacity to repay as well. So it can often form the basis of a complaint if the lender hasn't done the right thing in accordance with the law.
Okay, great. I think that summarises the Credit Act really nicely. So could you talk to us now about the Enhancements Act and when that applies to payday loans?
Sure. So the Enhancements Act is that second piece of law that I was talking about that applies to payday loans. The Enhancements Act applies to small amount credit contracts, which are payday loans. And as I said before, a payday loan is an amount that's less than $2,000 and where the term is 1 year, but less than 16 days. So between 1 year and 16 days. And the Enhancements Act, as I said before, applies to loans entered into from March 2013. There are new responsible lending presumptions and obligations for payday contracts within the Enhancements Act, and the intention there is to address the risk of debtors spiralling into a debt spiral.
Okay, so what are the actual obligations of lenders under the Enhancements Act?
So the additional responsible lending requirements, there's a number of them. So I'll just go through them now. The first one is that the lender must obtain and review the bank statements of a consumer for the previous 90 days when verifying their financial situation in relation to the payday loan application. So that's the first step that needs to happen. Secondly, the lender must assess a application as unsuitable where the borrower is already in default under another payday loan, or in the 3-month period before the lender makes their assessment, the consumer has had 2 or more payday loans. So in those circumstances, the borrower will be deemed to only be able to pay the loan with substantial hardship, and that's unless the lender can prove the contrary. So that protection is essentially trying to prevent people from getting into that debt spiral and entering into unsuitable contracts where there's some red flags, like already being behind in a payday loan contract or having a number of payday loan contracts in a 3-month period. Another protection is that a payday lender, must not enter into a contract with a consumer if the consumer receives at least 50% of their gross income as payments from Centrelink, and the repayments in a payment cycle would exceed 20% of the consumer's gross income.
Right, okay. So I guess then that would be a matter of sitting down and making those calculations. And obviously the people watching today can make those referrals. So the next thing I want to talk to you about is it looks a bit complicated whether they've met these responsible lending obligations. So when our clients go to get a payday loan, what do they actually do?
Good question. So yeah, what can your client expect when they're getting a payday loan, or what kind of experience has your client had when they've applied for a payday loan? So like I said, they have to provide documentation to the lender so that the lender can conduct reasonable inquiries and verifications about the financial position of the consumer. And so in the context of payday loans, there's those bank account statements. So the lender has to ask for the previous 90 days of statements for the bank account where the consumer's income is paid into, and that includes Centrelink payments. And if the consumer's income is paid into more than one bank account, they must provide 90 days of statements for each account. They don't have to be paper statements. They can just be printouts from internet banking, but the lender might ask you for additional details to confirm that you're the account holder. There's also other information that the lender might ask for to work out if the consumer is able to meet the repayments of a payday loan. For example, they might ask for pay slips or Centrelink statements, copies of recent bills, copies of other credit contracts or statements of accounts, or rental statements showing if you're up to date with your rent. And basically those documents are useful for the lender to check the consumer's financial situation before they give you a loan. And the number and type of documents that a lender asks for may depend on whether they've dealt with the customer before, may depend on the person's credit history, what information is contained in the bank statements. And so, as I said before, it's pretty unlikely to get a payday loan if your bank statements show that you've had 2 or more payday loans in the last 90 days, or if you're spending all of your money each pay and you're unable to meet your expenses, or you've missed a payment on another payday loan or another loan, for example, a credit card or a personal loan. So those are some red flags, or they should be red flags for lenders when they're reviewing the consumer's 90 days worth of bank statements.
Okay,
so,
great.
Yeah.
So would you give us a smart tip then about, if a client is looking at a payday loan, do you have any quick tips?
Yeah, so what I would say, I would still talk to my client about different alternatives, and I'd probably make a referral for my client to see a financial counsellor. But I would encourage my client to shop around to make sure that they're getting the best deal possible. There's aggregating services to compare fees on different credit providers. So I'd encourage the client to do that. But I think as a first step, I would encourage the client to consider alternatives and to maybe seek some extra support from a financial counsellor.
Great, thanks Dana, that's great. So we might have another poll now, and Jess will lead the poll question as a review of the information that we've just discussed so far.
Okay, so we've got the second poll question is Shirley is applying for a payday loan from small bank. She is in debt with little bank for another small amount credit contract. And the question is, why should small bank not provide the loan to Shirley? So the options here are A, she's already in default under another small amount payday loan. B, she has had 2 or more small amount payday loans in the 3-month period. C, she is receiving more than 50% of her income as a payment from Centrelink. Or D, the loan does not meet her requirements. So the question again, just to confirm, was Shirley is applying for a payday loan from small bank. She's in debt with little bank for another small amount credit contract. Why should they not provide the loan to Shirley? Okay, so I'll close the poll now and share the results. So we've got 38% of people have selected A. Dana, what is the right answer?
The right answer is A. Shirley, as the question said, is already in default under another payday loan, and so where that happens, then that's a reason for small bank to not provide the loan to Shirley according to the Enhancements Act. The other answers are a little bit of a red herring, but if it was the case that Shirley did have 2 or more small amount loans, or she received more than 50% of her income as payments and 20% of the repayment would be towards the payday loan, then those answers would be correct, but they weren't mentioned in the question themselves. I'd just like to note on a slightly different topic that there are other obligations on payday loan providers, for example, disclosure obligations and hardship obligations where people are finding it difficult to make repayments. But this presentation is sort of narrowing its focus about the responsible lending obligations, so I won't go into too much detail there.
Okay, great. Thanks for that, Dana. Now, I know we touched on this briefly in your smart tips, but I think we need to go into some detail for the people listening today for their clients. So are there any alternatives to payday loans, and what options are there for our clients?
Yeah, so the first option is that the client could instead apply for a no interest or a low interest loan. Good Shepherd's NILS program has been very successful, and there's a number of other loans that they can provide as well. They do have a payday loan alternative, which I think is called Speckle. So just to think a little bit about the no interest or low interest loan, where the client's on a low income, those kinds of loans can be used to pay for essential household goods or personal services such as medical treatments. And these loans can be more appropriate than payday loans because of the low to no interest rate, which stops the client from being trapped in a cycle of debt to pay down the additional fees, which are typically attached to payday loans. The second option could be to kind of cut out the credit middleman and just negotiate directly with your utility provider or your landlord, whatever it is that you need the money for. Go directly to that source and talk about your circumstances of hardship. So, for example, if a client suddenly requires money to pay for an unexpected power bill, say it's at the end of summer or winter, or if they've fallen behind in their credit card payments after Christmas, the best advice can be to contact the energy provider or the credit card provider and try to enter into a hardship repayment plan rather than getting into more debt to pay your debts. And so most companies these days have hardship officers who can help the client work out a plan to pay the bill in instalments or apply for an emergency utility bill voucher. Yeah, so I think, Jess, some of these links some of the information that I'm referring to is going to be sent around to the participants afterwards. So if you're interested in anything that I've been discussing, know that we're going to share some information. The third alternative is a Centrelink advance payment. So where your client receives Centrelink benefits, they may be able to apply for an advance payment with no interest charges. And clients can access information about how to do this through the Department of Human Services website. So basically the take home is that if your clients need money because they're experiencing financial hardship, there could be cheaper alternatives to a payday loan. So it's important to kind of raise those with your client. And I just note as well that if your client is in crisis and needs emergency relief or emotional support, there's an urgent money help page on Legal Aid's website, and we'll send round the link to that shortly afterwards.
Great, thanks Dana. You've given us some really useful alternatives that we can recommend to our clients. So what we're going to do now, everyone, is we're going to have a look at a case study, and for the purposes of this webinar, we've de-identified the client. So this is Caitlin. Yep, and Caitlin is a single mother who has racked up a lot of credit card debt and has been taking out payday loans to pay her credit cards and her electricity account debt. She's had 8 payday loans in the last 6 months, and she's in receipt of a Centrelink payment, and she works part-time. So Jess is going to do a poll question in relation to that scenario now.
Okay, so I'll just leave the information up for a second while I read the question out first. So the question will be, what could Caitlin have done instead of taking out this loan? So our options here are she could have negotiated with her electricity company. She could have applied for a hardship application with her bank. She could have used Centrepay with Centrelink, or all of the above. So I'll give you a couple of moments to select an answer there. Okay, and I'll close the poll and share the results. So we've had 100% of people have selected D, all of the above. Dana.
Excellent. So that's what I would have said as well. The alternatives that Caitlin could have used instead are going directly to the sources of debt and talking about her financial hardship and working out a moratorium on payments or a reduction in payments until she gets back on her feet. Caitlin might also consider going to see a financial counsellor to assist with her financial hardship, and she might benefit from speaking to a lawyer. I'm just thinking about those 8 payday loans that she's taken out in the last 6 months. That could be a breach of one of the prohibitions in the Enhancements Act about signing up to 2 or more payday loans in a 3-month period preceding the new payday loan application. So potentially she might have an argument there that the payday loan provider has done the wrong thing, and she might be able to be refunded the fees and charges that she's paid above the principal amount of the loan.
Okay, thanks Dana and Jess. So we've got one more example here where we've de-identified a client. It's a common scenario that I'm sure we've all seen before. So this is Leah, and Leah's car broke down on the way to work. Leah took her car to a local mechanic, and he said he could fix the car by tomorrow, but it would cost Leah $1,500. Leah works part-time as an aged care worker, where she receives $200 gross per week. Leah also receives Centrelink benefits of $400 gross per week. Leah needs her car to visit her patients. Leah knew she wasn't going to be paid for another week and didn't have any money in savings. So Leah visited her local Cash for Me Now shop to get a quick loan for her car repairs. Leah knew she could get a loan quickly from Cash for Me Now, as she'd already had 2 loans with them in the last 2 months due to her washing machine breaking down and a very large electricity bill. She gave the Cash for Me sales rep 1 month's worth of bank statements. She was then approved for a loan of $1,500, which she was then required to pay back for a period of 12 weeks at $165 per week. Leah was granted the funds to set up a direct debit from her bank account to repay the loan. Leah's now 10 weeks through her repayment plan and says she's really struggling to get by. She's unsure whether she'll be able to pay her rent this month. So in relation to that scenario, Jess is going to put on a poll question.
Okay, so the question for this one is, how many times has Cash for Me Now broken the law? So We'll launch the poll. So the answer options are 1, 2, or 3 times. How many times do you think Cash for Me Now broke the law? And I'll just give you a couple of moments. Okay, great. And I'll share those results. So we've got a pretty even spread here. We've got 40% with 2, 50% with 3, and 6% with 1. Dana, talk to us.
So the answer is 3 times. So let's just go through and identify the 3 breaches of the law by Cash for Me Now. So the first issue is that they have only gotten 1 month's worth of bank statements. They haven't taken 90 days worth of bank statements from Leah. So that's the first breach of the law. The second is that they haven't assessed the loan as unsuitable for Leah because she's already been granted 2 payday loans in the last 3 months. So that should have been the other red flag for Cash for Me Now when they were looking through her bank statements and having a chat to Leah. They should have realised that she's had 2 payday loans in the last 3 months, and as a result, it's not suitable for her to sign up for another loan. And the third breach of the law is that Cash for Me Now shouldn't have entered into the credit contract with Leah, as more than 50% of her income is from Centrelink payments, and the repayment amounts were more than 20% of her gross income. So the repayment amounts for the payday loans. So that one was a bit tricky to work out, that final one, because you had to do some quick maths in your head. But that's the 3 breaches of the law that came up. So Leah should really get some further legal advice about her matter, and she might be able to lodge a complaint, an internal dispute resolution complaint with Cash for Me Now on the basis that the loan was unsuitable and that they've breached various requirements of the Enhancements Act. So if you speak to a client who has similar set of facts to Leah or to Caitlin, then you'll be able to refer your client.
Okay, thanks Dana and Jess for stepping us through that. So Dana, you were just saying if you believe that your client, the lender hasn't complied with the Enhancements Act, what can they do? So can you talk to us about what workers should suggest to their client and what they think their client should do if they do believe that a credit provider has failed to meet their obligations?
Absolutely. So where you think your client, where you think the payday lender hasn't done the right thing by your client, where they've breached the responsible lending obligations in the credit law and some of those protections we've been discussing in the Enhancements Act, you might want to refer your client to a lawyer to get some legal advice. So what your lawyer would do, or indeed what the client could do themselves, or what you might be able to assist them to do, is to make a complaint. It's called an internal dispute resolution complaint, an IDR complaint, to the payday loan provider. And basically you would set out the issues there, so the particular areas of the law that have been breached and how the loan has been unaffordable for the consumer. If that doesn't resolve the matter, then you can make a complaint to an external dispute resolution scheme. So the Financial Services Dispute Resolution Scheme is the Australian Financial Complaints Authority, AFCA. And external dispute resolution, so AFCA, is free to the consumer, and they don't lose any of their rights to go to court if they're dissatisfied with the result that they get through AFCA. Consumers don't need a legal representative to go to AFCA, but financial counsellors or lawyers can advocate on behalf of the consumer. And AFCA is essentially a one-stop shop for financial complaints and disputes about financial services. It used to be 2 schemes. It used to be the Financial Ombudsman Service and the Credit and Investments Ombudsman, but they've merged. They merged in November last year, and AFCA now covers all providers of financial services, and they hear a variety of complaints about credit and finance and loans, about insurance, investments and financial advice, and about superannuation. But before a client complains to AFCA, it's important that they complain directly to their financial firm or the payday lender first, using their IDR process. And if you want to find the financial firm and their contact details, you can go to the AFCA website and use their Find a Member tool to find the complaint contact information for the payday lender. It's important to think about what outcome the client wants, so what kind of outcome they want to achieve. Where there's been a breach of the law with the kind of laws that I've been discussing today, it's typical for the client to have to account for the benefit that they've received. So if they have received a $100 loan and used that and spent the money in their own life, then they will have to pay back the amount that they've spent, but they may not have to pay back the extra fees and charges and interest on top of that $100. And the rationale behind that is that the lender shouldn't be able to benefit from breaching the law, that is taking extra money from the consumer when they've not done the right thing by the consumer. But on the other hand, the consumer can't be unjustly enriched and can't take the $100 benefit, leaving the payday lender out of pocket. So that's kind of the rationale, and that's a common outcome that I assist my clients with, which is reducing the amount that they owe back down to the principal with no interest and fees and charges on top of it. And so when making a complaint, it's important to collect any relevant documents that might support your complaint. So before you make a complaint about a payday lender, typically I write to the payday lender and ask for a number of documents. I talked about the assessment earlier on, but I might also ask for the documents that they relied on, for example, the bank statements or payslips or Centrelink statements, and I use that to kind of paint a picture of what their process was at the time. I might also talk to my client about their financial difficulty currently, and I might refer them to a financial counsellor to fill out a statement of financial position. So the final option when you're making a complaint about a payday loan is an option of last resort, and that's to go to court. Often going to court, it doesn't make sense on a cost-benefit analysis because the amounts in question can be quite small and the cost of going to court can be quite large. So it's a really good idea to get legal advice first and to consider making a complaint to AFCA in the first instance before going to court. You can also make a complaint to ASIC about the payday lender's conduct through their online complaint form on their website. ASIC don't work out individual outcomes for consumers, but rather it's kind of like a way that they can gather intel and then do investigations about the conduct of the industry, and then perhaps take steps to reach a solution for a group of consumers who've been affected by that particular conduct.
Oh, that's great, Dana. Well, that's a really good run through of all the remedies that are available to our clients if we feel like they may have been adversely affected by a payday loan. So what I want to talk to you about now is you've talked about what remedies are available. So where do we send our clients to get help? Where would you suggest that where we tell our clients to go to first if we feel like they have had an issue with a payday loan?
Yeah, so speaking to a legal aid lawyer is a great place to start, but there are other legal services that have a similar expertise to legal aid lawyers, for example, community legal centres in the client's area, but also consumer credit specific legal centres around Australia. There is a credit and debt hotline. The number is 1800 007 007, which puts you in touch with the consumer credit legal centres and also financial counsellors, which can be a really good starting point to refer clients to. Yeah, as I've said throughout the presentation, financial counsellors can be a really excellent resource in assisting clients who are experiencing financial hardship. And of course, you can refer your client to the Australian Financial Complaints Authority, AFCA, as well. As part of my advice to clients, I'd remind my client that there's time limits to apply to get an outcome if they think that the payday lender has done something wrong. So typically it's 6 years from the date that they entered into the payday loan contract, or if they've already complained to the lender through internal dispute resolution, if they've already made one of those complaints that I discussed a few minutes ago, then they only have 2 years to make a complaint to AFCA.
Right, okay. So we will include in an email to everybody at the end of the webinar a link to the places that you just spoke about, Dana, where we can refer clients for help. So thank you very much for that. And I would like to just thank you, Dana, for all your knowledge today. You've really summarised it quite well and simplified what can be often a complex and confusing area of consumer law, but one that, you know, a lot of our clients are affected by. So it's really good to have the basics on it. So we will now stay online for a couple of minutes to answer any questions. And Jess, thank you for everything you've done for organisation today. And Jess will read out any questions that come through on the poll.
Great, thank you guys. So if anyone has any questions, now is the time to type those into your question panel. We'll just mute ourselves for a moment. Oh, no, we've already got one. So I've got a question. What protections are there for clients with limited skills?
Okay, so I'm just thinking limited skills. I'm wondering if that means reduced capacity to enter into contracts. So if I'm, okay, cool. I think I'm understanding the question correctly. So in that particular case, I might then just make an argument that the client didn't have the capacity to enter into a contract at the first instance. I'd just make it very simple and maybe support that argument with a letter from the client's healthcare professional about their capacity and about the particular limitations, and based on that, I would ask that the contract is completely voided so that the client doesn't have any ongoing obligations to make repayments.
Great, so we've got another question now. Following ASIC's action on Signo, what will happen to the existing debts? Is there any indication?
That is an excellent question. So the use of the product intervention powers by ASIC that's been in the media a bit recently, that is going forward. So any existing Signo contracts prior to when the product intervention powers were exercised last month will stand, and that means that it's important to continue advocating on your client's behalf about their financial hardship and about if you think that Signo has done some wrong things in signing up the client for that particular financial product. You could also refer to ASIC's exercise of the product intervention powers and include a link or a part of ASIC's media release as a way of bolstering your complaint letter.
Okay, great, thank you. And what age can a young person apply for a payday loan?
So you are able to enter into a contract once you're of legal age, so once you're 18, but there are certain provisos where you're a young person who is emancipated or has independence. But I would say a simple answer to that question is that you need to be 18 and over. And if you're not and you have some concerns about the process of signing up, I would go and chat to a lawyer about it.
Okay, great. And just to follow up from the previous question about capacity, does it make any difference if the application for the loan has been made over the internet?
I don't think so. I think it's still open to make the argument that the client didn't have capacity and to make the argument that a lender's processes should be able to make an adequate assessment of a person's ability to service a loan and to enter into that loan contract. So I would just make the argument, I would address the point that it was made online and also review the documents that were submitted online and any notes that accompany the file, just to see if there were any red flags that the lender should have twigged to. And you can also, of course, think about making some responsible lending style arguments. So if the person immediately defaulted on the repayments or already was in financial hardship when they were signing up, all of that can kind of bolster your argument that they shouldn't have been entered into the contract in the first place.
Wonderful answer. Okay, so that's all the questions we have received. You all seem to be very well informed from this webinar, which is good. So we might leave it there. If there are other questions, the cle@legalaid.newsouthwales.gov.au email address is on the screen now, and you can send us any extra questions to that email inbox, and we'll have a look at those later. But thank you so much for attending and for participating in today. You guys really make these live webinars so much more interesting, and we learn so much about what we can teach you guys in the future. Please make sure that you tell people that you know about our webinars and about our Community Workers program. And that's all from all of us today. Goodbye, everybody.